Good evening, everyone. Thank you for coming to this community town hall on investigative grand juries. First, I'd like to do some introductions, and then we'll talk about sort of the ground rules. And would like to welcome some folks here that Representative Sarah Vance, thank you for coming. Representative Elam, thank you for coming. Other elected officials. Former Representative Ben Carpenter is here. Thank you all. You're all equally important to all of us. Just wanted to point out the fact that folks did take the time to come that are representing you elsewhere. So I'd like to introduce Attorney General Treg Taylor and have him say a few words.
Thank you. Good evening. Pleasure to be here today. I was hoping with a sunny day and a plethora of silvers that the crowd, I'm actually excited that the crowd's this big because this is an issue that's been festering for quite a while, and hopefully we can have a great discussion today, put to sleep some of the things that some of the misinformation out there on this subject, and then come to sort of maybe a better understanding of the process and why it is the way that it is. And I'll be frank with you, and we'll probably have more specific discussion on this about why I'm dissatisfied with the process as the Attorney General. And also wanted to thank a lot of you in this audience for pushing this issue. It is a very important issue for Alaskans. And I think that a lot of the points that are being made by the group pushing this is right on, actually, right on, and needs more attention, and we need better answers. But we're going to go through a process slideshow here to kind of introduce you to what we've done in response to the change of rules by the Alaska Supreme Court, why we did what we did, why we think it actually is an improvement on the process. And then sort of talk maybe about where I disagree with the courts on this issue. But to the left of me is Ann Heltzer here in our office, and she's a Chief Assistant Attorney General. She does special projects for me, and so obviously this is a special project that has our attention and has our problem-solving motors running, trying to figure out the best ways to address some of these issues that we see. And with that, I don't know how do we do the slideshow?
Let me just go through the agenda,
Okay.
if you don't mind.
Yeah,
What do I call you? Mr. Taylor, AG, General?
Treg's
Treg,
fine, right?
okay, Treg works.
Treg's fine, yeah.
I'm Peter, nice to see you again. So we'll do welcome and introductions. I really want you to welcome our guests. This is a big deal. We're glad to have them here. And this may result in additional meetings, but we know you're interested, and we know it's a lot of you are very passionate about this issue. So what I wanted to review is why we're here, and that's Section 8 from Article 1. No person shall be held to answer for capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the armed forces in time of war or public danger. Indictment may be waived by the accused. In that case, the prosecution shall be by information. The grand jury shall consist of at least 12 citizens, the majority of whom concurring may return an indictment. And then at the end, which is obviously very important to the writers of our Constitution, is a sentence. It says the power of grand juries to investigate and make recommendations concerning the public welfare or safety shall never be suspended. And I'm not going to read through this is a great book, Alaska's Constitution, a Citizen's Guide. I don't know how many of you have this book, but it is a really great resource for them explaining what was intended by the writers of the Alaska Constitution and what they meant. They were focused on this, and it was very important to them. The last section talks about grand juries being able to investigate crimes, particularly cases of white collar crime and political corruption. Read it for yourself. It's a worthwhile read, but it was their intention for a grand jury to be able to investigate. So after that, Treg will provide a presentation for 25 minutes. We're going to have public comments and questions. 60 minutes total. We're going to 3 minutes per person other than Mr. Haig, who's going to have a little extra time, 5 minutes to chat. I don't know if you want to go first or last. That's up to you, David. And then we'll have some closing comments for kind of where we go from here. So Attorney General Taylor, it's all you.
Thank you, Mayor Micciche. Really appreciate you making this venue available as well. Great place to meet and sort of discuss this. I do wish I didn't have this wall in front of me with all of you. But let's go ahead and load the slideshow here that we've kind of designed here to kind of run through some of the aspects.
No, thank you. We don't. So this is a public meeting. There'll be public testimony at the time, so. Yeah, we're not going to talk back and forth, but we look forward to your public testimony when it's time to speak. So thank you. It's town hall.
Perfect. And just let me get a clarifier. So are they able to ask questions at the end and have answers? Sure. Okay, perfect. I was hoping that would be the case. All right. So here you have the first slide, obviously just an overview of who Ann is, who I am. If we go to the next slide, please. Thank you. So the mission for the Department of Law is to uphold the rule of law, protect public safety, and provide high quality legal representation to executive branch agencies for the benefit of all Alaskans. So those are our core duties. And we created this mission when I first came on to sort of define who we were and what our goals were. And with the mission, it enabled us to set goals to try to better the services that we offer. We go to the next slide really quick here. So where were we and what was in existence before this rule change? So there was only one really clear route to request an investigative grand jury, and that was if a member of a criminal grand jury brought up an issue for investigation, and if the rest of the grand jurors in that grand jury decided they wanted to investigate that, then they could proceed with an investigation. That was the clear one route to get at an investigative grand jury. And because the request for a grand jury occurred within a grand jury, it was a confidential process. No one would ever know outside of that grand jury that the request had been made and whether that request had been denied or granted, right? So if somebody brought up an issue, for example, and said, we believe that there's public corruption in our Department of Transportation, and the rest of the grand jury looked at the issue and said, yeah, we're not really interested in taking that on. We don't think there's anything there. And they voted and they decided not to pursue it. That would never become public because of the confidential rules that the courts have put around grand juries. The other thing is, even if they investigated, say they went a full, 6 months investigation, called in witnesses, called in testimony, asked for documents, subpoenaed files, did all of that work. The people that were called in as witnesses would know what was going on. And I believe that's what happened with one of the cases, right? That's why one of the only reasons we're aware that investigative grand jury occurred was because witnesses that were called in talked about that. And then also it resulted in a public court case afterwards. But otherwise we would have never even known that they had operated and did their job. And so that's a hard part, because really what it puts us in a position of, we can't talk about it. We can't talk about the grand juries that are going on because it's confidential under the rules. And therefore the public would never know it occurred. And so we could have had 5 grand juries since that one that resulted in the courts not allowing the public report to go out since then on the same issue. And if they voted not to proceed or they voted not to issue a report, the public would never know that. And so it's only if the report is made public does the public ever become aware that these grand juries occur, right? And so that's, to me, is a bit of an issue, right? That's a conundrum. It makes it hard for government to defend itself because we can't really step out there and say, oh, actually, we did have a grand jury on this subject. The grand jury didn't think that the evidence was credible, and therefore they didn't want to investigate further. I could never say that. And so that is a conundrum. So let's go on to what the way it is now with the new rule that the Supreme Court issued. Now, there's always sort of this amorphous way to do the second route to request an investigative grand jury. The problem is there's no rules in place, or no procedures in place, or no process in place. So people who thought, you know, maybe their local police force was in cahoots with the Forest Service and funneling money into whatever the corruption might be, right? Say you thought that. Where did you go to get it done? Do you wait for to be seated on a grand jury to be able to bring that up? How do you apply? How do you apply to a grand jury? There was no process for that. And so one of the focuses I've done since becoming when the courts changed the rules was to make sure the public knew what the process was, right? They knew exactly what they needed to do and have their issue heard. And so now we do have a clear second route. There's a process. If you go to our web, we're going to actually walk through it in a little bit, so I won't get into that. But there's a couple great things about this new process that we've created. One is it's accessible. Everybody knows it's public, what the process is. Everybody knows what the steps are that they need to complete. It's not some guessing game. Do I write a letter to the governor? Do I write a letter to the local police force? Do I show up at a court and say, can I talk to a grand jury? There's no question about what that second round is. Now that first route still exists, right? But now we have clear second route and procedures. So that becomes more transparent, because this process, when you apply to the Attorney General's office now to have an investigative grand jury, that's outside the grand jury process. I can talk about that. I can put it up on the website that there was a grand jury request for this type of public corruption or health and safety issues, right? And I also, outside of the process, get to say whether it was sent to an investigative grand jury, right? So there's a lot more transparency in the process, because now on my website, I can say there was an allegation that Anchorage Police Department is corrupt. That issue was sent to a grand jury on this date. And then obviously once they enter grand jury, that process becomes confidential. Not even I get to know about that, especially if it's an independent prosecutor that we typically appoint in these, because, well, usually I'm part of the complaint, right? Or someone in my department is part of the complaint. So it's always usually an independent prosecutor. So in the one that went on, for example, I don't know what was in that report because it was confidential, and it was an independent prosecutor that was pushing that. So so on that public website that we're going to have on the Department of Law, we're going to put what the issue was, when it was sent to an investigative grand jury, and whether or not that resulted in a public report. And if it was resulted in a public report, then we put that report right there for everybody to see. So that's the plan with this new process. So it is a more transparent process because a lot of it occurs outside of a grand jury, which is confidential under the rules. Let's see. Let's go to the next slide. Next slide here. Talk a little bit about what the cases are, and I'll try to get through because I want to make sure there's plenty of time for questions. Public welfare safety standard as defined by the court's rule in 6-part. So the court has defined what public welfare and safety standards, whether you like it or not, the court has decided sort of what the parameters on there. And then systematic or reoccurring issues that affect the public welfare or safety. That's what the investigative grand juries are for. So if it's for example, if it's a dispute between neighbors over a fence line, that could never rise to what the investigative grand jury is for. It's more of a widespread corruption type issues that affect public welfare and safety. The investigation of the issues involves a matter of importance to many rather than a single person. Okay, that's the same thing. So if you thought that in a criminal prosecution, the jury got it wrong, then this isn't a matter that would come before an investigative grand jury. Now, if it was a series of those prosecutions that all seem to favor one side or the other, or there was thought that there was corruption within a multiple, like maybe there's a single prosecutor that was doing things irresponsibly. That now is a matter that would, under the court rules, the rules that they created, that would now come under the ability to request an investigative grand jury for that. Next slide, please. So this one talks about the citizen's right to request a grand jury. And again, there's some important points in there that the power of this is all with the grand jury. Like they're the ones in control. For example, if I filed a complaint tomorrow where I thought that there was widespread corruption in payroll and that they were intentionally not paying public servants what they were under their collective bargaining agreements. If I filed that and they took the complaint, and investigative grand jury looked at it, the investigative grand jury gets to decide what witnesses come forward. They get to decide what documents they see. They get to decide whether or not they even want to pursue the claim. That's the power of a grand jury, and they hold all the keys, right, to the car. And so in that instance, I could file the complaint, a grand jury could occur, and they could never ask me to testify. That's the grand jury gets to decide that as a whole. Then they can decide not to pursue an investigation like I've talked about before. Or they can choose to investigate. And then when they get certain evidence in, they're like, yeah, there's nothing here. We're not even gonna bother trying to issue a public report. That's all within the power of a grand jury. They actually have a ton of power right now. They can also indict at the end of the day. They can do an investigation and indict. On the criminal side, that's a very powerful mechanism that grand juries have to hold people accountable. Next slide, please. So under the process, if a complaint has come in that implicates the Department of Law, we immediately push that request out to an outside counsel, so an independent prosecutor. In fact, we have one now that we received, and we've already pushed out to an independent prosecutor because it implicates pretty much all of the leadership at the Department of Law. So that is now in the hands of an independent prosecutor, and that prosecutor will impanel a grand jury, an investigative grand jury here in the next few weeks. And the grand jury will decide what they do with that case. Again, all of the power and control is with the grand jury at that point. And the independent prosecutor is really there to be their legal counsel, right? Hey, how do we subpoena this witness? How do we get these documents? How do we file this motion with the court? How do we get rid of you, the independent prosecutor, and hire a new prosecutor? All those things are that in this particular case, the independent prosecutor will answer those questions. So the court created this series of thresholds that need to be met in order to be a matter of public safety, public welfare concerning more than just an individual, right? And so in the case of when there's a conflict, for example, this case will go out to that independent prosecutor. They'll make the decision whether it meets the threshold, and then they'll impanel the investigative grand jury. And there's what I just said. The department has received a case since July when we rolled this out, again, implicating probably the entire leadership at the Department of Law, that has been sent to an independent prosecutor that has no ties to the Department of Law. Other than that, I pay the bills, right? They don't submit timesheets. They don't submit anything. They just submit bills. So I have no insight into that process whatsoever. Other than that, I pay the bills for that. Next slide, please. And this is where I'm going to turn some time over to Ann here to answer sort of what does this process look like? What is this? How does somebody submit a matter for investigative grand jury?
Thank you so much for, I want to thank the mayor and the leadership, Treg Taylor, the Attorney General, and all of you for coming. I'm very excited about this rollout. A little bit about me, I have been an attorney for many years, and for most of that time, I've represented individuals who had complaints with various state agencies, cities, boroughs. I have helped hundreds of people in the state of Alaska on those everyday sort of issues to fight City Hall. So I am very well equipped to have and welcomed this project to assist the Attorney General on building this forum, this platform, so that people who carry frustrations about government, about uh, any matter of public welfare or safety, that they have a place to go now with that. And that's a treasure. That's I think what the constitutional basis for this was, that you don't have to sit in your living room anymore and just figure out what am I going to do with this. Now you have an easy access, and this is what I'm going to show you. I'm going to walk you through the program. You have something easy to look at and to fill out. And as long as you meet the requirements for the appropriate types of cases that grand juries hear, you know, you have a very good chance of bringing something of great importance for the benefit of the entire state of Alaska, which is a tremendous privilege. And I'm tremendously grateful and proud to be able to have worked on this project and continue to do so. So needless to say, I welcomed this opportunity to assist Attorney General Taylor on this important initiative that he had. I started out by talking to a number of you. Many of you I've met with, including Representative Carpenter and others, about what the frustrations were. And then we all as a team at the Department of Law studied how we could incorporate the Supreme Court orders in as transparent and fair as a matter as possible. And so this is the website, you're looking at it. The way you access this website is you go to the Department of Law website and you go to Law Resources, which is the tab under the Department of Law website. And then you go from there to Investigative Grand Juries. And you're going to see the following page, you're looking at it. There is the policy and procedures. There is the form itself, some FAQs, and hopefully that'll give you, if you get a chance to look at that, it'll give you some context for how this was all sort of developed. Next slide, please. So the first thing that you need, the only thing you really need to do when you want to request an investigation of a grand jury is you need to complete this form with the Department of Law. And I'm referring to the process that a citizen, an Alaskan, must avail themselves of in order to request an investigation. And the questions are rather simple, but what we look for are some very specific things. One is this a matter of public welfare or safety? Is this a systemic, ongoing, or recurring situation? Okay, so we're narrowing this down according to the Supreme Court criteria for what a grand jury investigates. And we are asking you as citizens, as Alaskans, to complete this to the very best of your ability and precisely so that your investigation can proceed. Keeping in mind that these descriptions, this form that you complete will go in its entirety to an investigative grand jury if one is impaneled because of your request. So I would encourage detail. And I see here, what section are you referring to? What agency are you referring to? What official are you referring to? And to provide the matter at the time, the date. All of these things are very important. Next slide, please. Okay. Okay. So this is all on the Department of Law website, and I strongly encourage you. Yes, it is very small. I apologize. I'm having a lot of trouble myself, and I wrote part of it, so I understand. And please let us know if we can do anything, but I don't know that there's anything we can do at this time. But this is the browse files. I'll just sort of explain it if you can't see it very clearly. The browse files is a wonderful tool. It's a drag box, okay? So when you have stated the description of your matter, you now want to provide evidence. And this is very important because speculation or, it's useful for the reviewers of this and the grand jury itself to have actual evidence, credible criteria, demonstrating that your allegations are true and correct. So please spend the time when you put this together to attach relevant, credible evidence to your application to support your application. And then the second list here is,
I'll interrupt there just a little bit. So the more information in there, it helps the investigative grand jury, right? Because the investigative grand jury just gets a bare minimum complaint and they're looking at whether they want to investigate or to subpoena witnesses. They may still do it, right? They still mail in panel and investigate, but your chances increase, your odds increase the more information you can put in there. And again, we understand that like allegation of public corruption, it's not like they're sending out mailers saying to your mailbox saying, I'm a public official and I'm corrupt and I don't care what you think. And you can't really, you're not going to have that kind of evidence. We totally understand that. We get that. We're just saying the more information you can put here, the better it is, and the more likely that an investigative grand jury is going to take it up and investigate.
Ms. Helzer, can I just read that slide to them?
absolutely,
Yeah.
yes.
Just
please.
so, and they're behind you as well, but they are hard to see. The top section says, please attach all pertinent documents, evidence, pictures, and correspondence, and include any relevant dates. Please use the upload function in the box below to electronically attach your documents. And it says browse files, drag and drop here. And the bottom box says, please list the names and contact information for any witnesses who can support the allegations made in your petition. The former slide, previous slide, can we go back one? Summary of the matter, section 1, include a detailed description of your complaint and how it concerns a matter of public welfare or safety. Issues generally must be systemic, ongoing, or recurring. You must attach documentation of the evidence you have in relation to this matter. Line below says, please provide the details of your petition for an investigation. Include details of any government action, section, agency, or official you believe should be investigated and why, and provide the dates that the matter at issue occurred or is occurring.
It doesn't have at least one browser file you can't see.
Correct. We do require there to be evidence attached to the petition. And that makes sense. We don't want empty allegations, and we want credible and supported allegations.
And I'll just jump in there as well. I mean, again, if you're talking about public corruption, it's not going to be like it's not going to be an obvious piece of evidence that everybody has. If it was obvious, then we would need an investigative grand jury for it. So just do your best here. If it is just dragging a piece of paper that says, I don't have any evidence other than what I'm seeing, and I see a trend in whatever it is. For example, the number of DUIs that are being dismissed in Kenai is like quadrupled over the last 4 years. Why is that? Or is there some kind of corruption going on? Are people paying off a judge or a police officer? So just if it won't submit without any of that evidence, just submit a piece of paper or scan something and put it in there that just explains, hey, this is just from what I'm observing. And I just know that investigative grand jury can still choose to pursue that claim, and then they're the ones that are supposed to find the evidence, right? They're the ones that are going to subpoena witnesses, documents, etc.
Thank you. So we're on the next slide. I will read it aloud just for everybody's benefit. This slide is referring to confirmation that a petitioner's, the members of the public Alaskans, and your beliefs on the matter and that fit the requirements. The first question is, do you believe that an investigation into the subject of your citizen-initiated petition could further a public policy of the state? The answer to that question should be yes. And the reason for that is because we don't get into personal complaints. As he mentioned, the two neighbors fighting over by the fence, that's not something that a grand jury would typically hear. However, something that furthers a public policy of the state, such as something that is impactful to the state, to the statewide, to an agency, to a section. These are matters that investigative grand juries can really accomplish the most in investigating. So we encourage that, and we'd like you to be able to say yes to that question. If not, an investigative grand jury is probably not your best venue to satisfy your problems. Do you believe that the impanelment of an outcome of an investigation conducted by an investigative grand jury can reasonably be expected to benefit a large number of people rather than to benefit an individual or small group or individual? This is also key. We have courts, we have other ombudsman's offices and other ethics offices that can take certain types of issues. The investigative grand jury is unique in that it can benefit large numbers of people, large groups of people, and it's not generally well suited for a single person's purely private complaint. So we'd like you to answer yes to that question. Do you believe the subject of your petition involves a matter of general importance to a large number of people rather than to an individual? Again, this is repeated because it is so essential to the credibility and the forum of an investigative grand jury. If it benefits only one person, it's generally not suited for an investigation. But if it benefits a large number of people, such as this group here, such as a population of people, a city, a borough, then it would be appropriate. Next slide, please. Okay. Now I'm going to have some trouble with this attestation, but that's okay. I don't need to go too deeply into this. I just want to explain it. So when you have completed the first few pages that I've just gone through, you should feel very proud. There will be a submit button. You will hit the submit button, and what will happen is your entire application will be available to you in a copy form in your email with a thank you note from the Department of Law. So you will go check your email and you will see a thank you note from the Department of Law and a copy of everything that you submitted to the Department of Law. So you have your own record. You've also received a confirmation that we have received your application. Now, in addition to the thank you, you will also receive an attestation and signature form. This is an additional form that we require to show your dedication to the truth and accuracy of what you have submitted. You are to initial each one of these paragraphs, and I can go through them with you, but not right now because I can't see that far. But they are relatively similar to what I have just explained. This is a public policy of the state. This is not a purely private matter, so on and so forth. And the statements I have submitted are truthful and accurate. The allegations are supported by evidence. This is not made up. This is very serious. And to show how serious I am, here is my signature before a notary public. You print that off and you have to send that in to the Department of Law, and your application is then considered complete. Why is this important? Because we want credible allegations. There is a lot of opportunity to abuse situations like this, investigative grand juries. People, their reputations, their livelihoods can be on the line. We want only those applications that are credible, and we appreciate the notary that is the case. I think that may be my last slide. Yes. So with that, I believe we are ready to take some questions, and hopefully this has been a productive program for you.
Yeah, thank you. We have folks that signed up to speak, and there's a few online. There's 101 people attending this meeting. There are 43 online, 58 in the room. So pretty good outcome for. We can start with questions on the presentation. If you think it's a part of your public testimony, it might be worth waiting for that. But if there's some quick questions, come on up and identify yourself and let's have a discussion.
A quick question.
Yes, push.
Okay, were there not, when you presented the way things were before the most recent changes, wasn't there even an earlier protocol, but was changed by the Bill Sheffield impeachment case?
I'm not familiar with that case and what occurred there.
I think there may be people here who do know that, and maybe they can answer it. And then the last thing is, if the complaint is against a member of the Department of Law, what guarantees does the citizenry have that the counsel that's been chosen is impartial?
Yeah, no, that's a big issue. And it's frankly one of the areas that I disagree with of the Supreme Court rule. I have no business being the gatekeeper on this. Absolutely does not belong with me. And so when this started to heat up down here, I kept talking to the courts. I had meetings with the Chief Justice saying, you guys have to deal with this issue because it's undermining public trust in the court system and in the justice system. And so I kept hitting that point. You guys need to deal with this. You, the courts, need to deal with this issue. And so ultimately, about a year into that, pushing the courts, they decided to finally do the rules. And so when we found out they were going to relook at the rules, we submitted what we thought the rules should look like. And I guarantee you, in those rules that we submitted, I was not going to be the gatekeeper, right? It doesn't make any sense for me to be the gatekeeper because I am typically, or somebody within the Department of Law is going to be the subject of one of these complaints. So it just doesn't make any sense. And then we have the added problem. So a lot of the way that some other states deal with this is they have sort of multiple different, like DAs, for example. DAs are elected. So if one county is under a suspicion of corruption, they could easily give it to the next county over or two counties over to impanel this investigative grand jury. But in Alaska, that doesn't exist because all the prosecution in the state is done by my office, right? Except for some low-level misdemeanors that the municipality of Anchorage does and Juneau does. And so by virtue of that, the vast majority of 98% of the active prosecutors in the state work from the Department of Law. And then the other 2% work for the federal government. And then what happens, where do we find these independent prosecutors? They're usually people that work for the Department of Law because they have the requisite experience on what it means to be what it means to be a grand jury. What are the rules associated with getting witnesses and information? So the whole process is especially with me being the gatekeeper. And if you look at the facts so if you go to the website and you read the facts, I talk about that disagreement in there with the courts that I have no business being the gatekeeper. You're absolutely 100% right. And so we go with an independent prosecutor. So in this last one that became public because of the subsequent court case about the judge, and because David Haig's made very public what happened in that at least the portion he knew about in that investigative grand jury. Now that was an independent prosecutor. He formerly worked for the Department of Law. But he get to make his own decisions on things. And I think one of the things I've heard criticism about is he impaneled a grand jury with only 12 grand jurors. Well, he's an independent prosecutor. I have no say in that, right? And so he made some choices there that some of you might have disagreed with. And I'm not trying to slam on a former prosecutor. I just think that what I'm trying to point out is the difficulties in trying to make this be a public process that people are going to have trust in, right? Because we do ourselves no service by, for example, releasing this report. If there was an individual madder than me that report wasn't issued, it would probably be David Haig, right? But I was very upset by that because they had an opportunity to release the tension down here, to regain people's trust in the system, and they did not do it. And I can understand, some of their reasoning, but I think the public right to know what happened in that grand jury outweighed sort of these trivial things like, oh, only 11 people voted on that public report. Because there wasn't 12 that voted, we're not going to release the document. Well, then release the document, but put a caveat on the top that says, by the way, this isn't an official public report because 12 jurors didn't vote on this, only 11 did. But in the interest of public knowing what happened and what occurred and the findings of those at least 11 people, here's the document. And of course, I couldn't push on Clint to push that out. He actually did file some documents trying to get the courts to put that out. But again, he was an independent prosecutor. I couldn't tell him, try harder, try more often, try more vocally. I mean, because he was in control at that point. And again, this isn't an indictment on I think Clint. I think Clint probably did a fantastic job with what he was given in according, but you know, the courts didn't. They chose not to release that report. And again, that really made me mad because it was my office that had some of the allegations, right? I would love for a public report to come out and tell me that there is corruption within my department or absolve us of the allegations of corruption, one of the two. But at least then the public has the information and then we can move forward. I can either make changes within the Department of Law, or I can say, okay, looks like we did everything that we were supposed to do and we were right. And then at least the public knows that. And so those are some of the issues.
Okay.
I'll address that because it's an important aspect. I don't know what's in that document. I agree with you that the document came up, but it's not a document I can release because I don't even know what the document says.
Mr. Haig, do you have a question?
I do, but it's sort of weaved into like some testimony. I thought I had 5 minutes, so it's kind of a combination, if that's okay.
Sure.
First, I'd like to thank Mayor Micciche and Attorney General Treg Taylor and Ann Helzer for coming down. My name's David Haig. I testified twice to the 2022 Kenai grand jury that wasn't investigating Judge Murphy. They were investigating a lady by the name of Marla Greenstein for falsifying official investigations to cover up for corrupt judges and keep them on the bench, and whether or not the Department of Law was covering that up. I'm going to go over facts which are in conflict with each other, mostly regarding SCO 1993, which is the Supreme Court order, and the Department of Law's new process. After I'm done, I would like Attorney General Taylor to explain and resolve these conflicts and tell us why and how the Alaska Supreme Court and Department of Law are not violating constitutional rights. SCO 1993 and the new DOL process positively states that citizens cannot appeal directly to the grand jury. The problem with that is the 55 delegates who wrote our Constitution said this specifically without a single voice in dissent. The grand jury can be appealed to directly, which is an invaluable right to the citizen. There is no getting around that. We are not going to be kept away from the grand jury. No one is going to be the gatekeeper. I'm sorry to say, you seem like a nice guy. You are not going to be the gatekeeper, period. Not on my watch. SCO 1993, the new DOL process state that only issues affecting many people can be given to the grand jury, and no court case, either open or closed, can be given to the grand jury. But this conflicts with what the 55 delegates who wrote our Constitution stated without a single dissent. And this is what they stated. The grand jury, first they said this issue can be utterly vital to the citizen. The grand jury essentially is an added protection to the citizens, specifically to criminal cases. The grand jury in its investigative power, as well as for the fact it is sitting there as a panel, sometimes is the only recourse for a citizen to get justice, to get redress from abuse in lower courts. It is the only safeguard a citizen occasionally has when for any reason, and very often for political reasons, a case is not dealt with properly. I am not going to let you bar individual citizens from appealing to the grand jury, not on my watch. Okay, you talked a great length about the independent counsel that we're going to trust you to provide to these grand juries. The Kenai grand jury apparently got rid of the Department of Law attorney advising them, a lady by the name of Jenna Grunstein, and asked for independent counsel. And they were provided with Clint Campion. I asked Mr. Campion how he was selected and why he never told the grand jury that when he used to work for the Department of Law as their chief assistant attorney general, he investigated all of the allegations, criminal allegations against Marla Greenstein, and absolved her of everything. How would it look if the grand jury found criminal conduct against Marla Greenstein when Clint Campion had exonerated her? He had an overwhelming, a compelling reason to make sure the grand jury never found anything. That's the hard facts. We don't trust you. Not on my watch are you going to give the grand jury independent counsel, because we have hard proof that you will not. You will lie to us. So again, you're not doing it on my watch. As far as whether this is constitutional, what is going on with Supreme Court 1993, which amends Rule 6.1 to make it far worse. Back when Rule 6.1 was first implemented, there were 5 Supreme Court justices, just like there are today. They had a dispute over whether Rule 6.1 was constitutional. 2 of the 5 justices said it was blatantly unconstitutional. And in fact, trying to find my notes here. This is what they said. So this is how all this came to be. Five judges, 2 of them said it's blatantly, but the 3 overruled the 5, or the other 2. This is what the 2 said. Criminal Rule 6.1, adopted by this court pursuant to its rulemaking authority, not only suspends the power of grand juries to investigate and make recommendations concerning the public welfare or safety, but also permits censorship of a grand jury report generated as a result of that power before the report is even published. That is exactly where we're at today. They knew what was coming down the pike. This is the Supreme Court justices. This rule is not the least bit deferential to the anti-suspension clause. Indeed, it mocks it. The grand jury and not the courts can choose matters on which it reports and recommends and the manner in which to do so. Criminal Rule 6.1 violates the anti-suspension clause of Article 1, Section 8 of the Alaska Constitution. That was before SCO 1993 made Rule 6.1 an order of magnitude worse. We're not going to stand for it. That Constitution is in Article 1, which is the people's rights. It's not in the executive branch. It's not in the judicial branch, or it ain't in the the legislative. Anyway, and just you can shut me down when I run out of my 5 minutes here. Well, and the justices said why they had to make these statements. A grand jury had investigated a guy by the name of William Sheffield for steering a $10 million lease to a campaign contributor, and a grand jury investigated, and they not only investigated, they recommended to the Alaska legislature to commence impeachment proceedings. And the judge that got the report, he said he had no right to not make that report public. That is how it's supposed to be. Those judges, we don't have to do anything. These new things are wrong, and the history shows it. And so we just have to go back and look at that. And again, look at what happened at the Kenai grand jury report. Doesn't it seem a little odd that the Kenai grand jury was investigating whether or not there's systemic corruption, that for possibly 36 years, Marla Greenstein has been falsifying investigations to cover up for judges, and judges step in and seal it? That ain't happening here. We still live in America. We're gonna put our foot down so hard. And yeah, you may drag it out for another year, maybe even two, but by the time we get angry enough, you're gonna see something awesome. The whole world's gonna see something awesome here. As far as you saying there was no established procedures for grand juries, this here is the original Alaska Grand Jury Handbook, published by the Supreme Court of Alaska. I'm going to just read 2 lines out of it. Charges of crime may be brought to your attention in several ways. Number 4, by private citizens heard by the grand jury in formal session with the grand jury's consent, not your consent.
Amen.
Another line, a citizen is at liberty to apply to the grand jury for permission to appear before it in order to suggest or urge that a certain situation should be investigated by it. Again, apply to the grand jury. We don't apply to Ann. We don't apply to Treg. We don't apply to anybody but the grand jury. Because again, if in fact you and the Department of Law are part of the problem when you're the gatekeeper, oh, I don't think this needs to go to the grand jury. My name's on it. I mean, it ain't happening. Simply is not happening.
David,
Okay.
you're on your third 5-minute period, but just think about that as you go forward.
I'm down to what?
You're on your third 5-minute period.
Okay,
so-
well, I have one last thing here, I guess. In SCO 1993, in your new process, it says basically investigative grand juries will only be impaneled after the Department of Law decides there should be one. In the original, this is the transcript of the delegates. They knew that wouldn't work. And they said this, they said, they were discussing it, exactly what you're now have. And they said, however, an investigative grand jury will only be called under certain specific circumstances. That's exactly what your whole process is. And somebody is going to have to find conditions pretty bad before an investigative grand jury will be called. Whereas a grand jury which is impaneled regularly, and you could tell me right now, how many grand juries are impaneled? 0 or about 20 right now, right here now?
There's a grand jury impaneled in every separate jurisdiction within the state as we speak.
Yeah, and there's multiple ones in Anchorage, correct?
Yes, we do have a high caseload.
Okay, so they're saying a grand jury which is impaneled regularly has full investigative power as well as power to consider indictments. The grand jury is there and may take any steps it feels that may be necessary toward an investigation. It does not have to wait for a call. So that's it. I thank you very much, but if you think this is going away, think again.
No, I know it's David, I really appreciate your comments. We agree on more than you think we agree on here. You know, your last comment, for example, yeah, any grand jury right now in the state, if a juror brings up an issue and the grand jury decides to investigate that complaint will move forward with an investigative grand jury. And so that's been the case. That's always been sort of the way that you do this. I love the fact that you use this old handbook because it does point out some differences between what happens now and what happens later. And so,
David, can you let him finish and then make
Yeah.
a comment, please?
let me address that a little bit. And the Constitution reads this. It says the power of grand juries to investigate and make recommendations concerning the public welfare and safety shall be suspended. Who has the power there in that Constitution? It's the grand jury. The grand jury decides who's going to come before it, what evidence they're going to hear, and if they're going to move forward. The power, as I said earlier in my statements, the power under the Constitution is with that grand jury. I love the fact that you hold up that old handbook. We looked at that many times trying to figure out what the process used to be like. Unfortunately, the handbook doesn't really talk about a process. You talked about a couple things in there. Let me address them. You said the grand jury is there and may take any steps that it feels may be necessary toward investigation. It doesn't have to wait for the call. So the grand jury doesn't have to wait for the call. And then the next part that you read in that grand jury handbook is this. It says a citizen is at liberty to apply to the grand jury for permission to appear before it. Again, the power is with the grand jury. What we've never had written for the whole world to see is a process for how that individual applies to a grand jury. Right? Now we do have a process for how to apply to the grand jury. And I want to address some other things that we agree on. Independent counsel. You're right. There's problems with the independent counsel model. I am fully aware of that. And it's hard. You can appreciate this, David, that it is hard to find independent counsel willing to take these cases on. Can I respond to your comments first, please? It is exceedingly hard to find independent counsel that is willing to take these issues on for obvious reason. Because if a grand jury does not go the way that the person who wants the grand jury to go, that individual is now part of the corruption and part of the system. And no independent attorney that I can pay on contract wants to put themselves in that way. They have families. They don't want to be in articles all over the state as being corrupt. So it's really hard for me to find people that are willing to take these cases on. Now we've managed to find a couple, and like I said, we have one that has allegations of corruption throughout the Department of Law. That is, we have a person selected to take that case on. And by the way, luckily, we were able to find someone that has never worked at the Department of Law. That's pretty rare. And so that investigative grand jury would be moving on. So that addresses the independent. The grand jury reports. I completely agree with you. The court has no business determining what report goes to the public and what report does not. That is up to the grand jury. And so I think that's one area where the court got it wrong. They should not have to submit their report to a court and ask for the permission to be published. I 100% agree with that. And like I said, I wish that prior report had been issued. Again, there's despite the rules and despite the problems, I think we are more transparent with this process than we've ever been in the state. Because I can indicate what issue is being investigated, whether or not it went to a grand jury, and I can also point to whether or not a public report was issued. So at least the public knows this issue, allegation of corruption, went to this individual, went to a grand jury, and then people can, if the grand jury chooses not to issue a report or a court, again, doesn't allow the report to come out, that's going to be noted in the file. So that's really transparent. Before that never could occur because all that occurred within a confidential grand jury process. Not even the grand jurors are allowed to go out and talk about what happens in a grand jury. That's pretty standard everywhere you go in the world. And then so we agree, David, on more things than you think. And I agree that there's still changes to be made. Again, in our facts, we point out again, this is the first iteration. We're still trying to figure out a better way to do this because we want the public to have confidence in the system, right? One of those ways is through a legislative fix, right? So talk to your legislators. I don't mean to throw them under the bus, but they can enact legislation that takes it out of my hands. I would love for that to happen because the last thing I need is somebody that thinks I'm corrupt because a grand jury didn't take up an issue. That's not in my best interest. And the last thing I want is for there to be corruption within my department and me not be aware of it, and it never sees the light of day, right? So we agree on more than you think, David.
For a meeting with you to give you hard evidence of corruption in your Deputy Attorney General, John Skidmore. A grand juror, former grand juror, is here today that Mr. Skidmore falsified what occurred in his grand jury to Mr. Micciche was there as a senator, and our Speaker of the House, Micciche, was there, and his statements are false or a lie or whatever you want to call them. To justify, John Skidmore walked in and stopped a sitting grand juror from talking to his fellow grand jurors about crimes. And our statutes in the state say an individual grand juror who has no reason who knows or has reason to believe a crime has been committed shall inform his fellow grand jurors who shall investigate.
Hey, David, please submit this.
I
And
have how many times?
have you
hundreds.
submitted it through this process? David, look, I'm telling you right now, David, if you submit that claim, I will push it to a grand jury. Okay?
Hey,
Okay,
guys,
I'll-
we're
so
not,
I'll
we're not
try.
gonna do
And
this.
So
And I
what I
wanted
want to
to,
say, David, is just, if you submit that complaint and the hard evidence that you have as the gatekeeper, and again, I don't want to be the gatekeeper. Let me make that clear. I don't think I have any business being the gatekeeper, but as the gatekeeper, I will push that to an independent prosecutor for investigation by a grand jury. You have my word on that, David. And it'll be public that I did or did not do it, because I'll put it right on the website that it went to an investigative grand jury.
and you know what?
You already know the information. Yeah, why
David, do you have any more questions?
Well, I just want to answer one of those things. He asked where they get independent counsel. I'll tell you what happened in the Sheffield case. Huge case. Governor going down. I mean, they wanted to charge him with perjury, and the independent prosecutor says, we don't know whether we can do that with a sitting governor. Their counsel came from Washington, D.C., and both of the opposing attorneys were former Watergate attorneys. That's what should have happened. So, thanks.
I'm gonna call folks as they signed up in order, if you don't mind, if that's okay. Mr. Harpring, you're next. I won't start your 3 minutes until after you start talking.
Thank you, Mr. Mayor. For the record, Jim Harpring, Waterfront Way, Funny River Road. I've been following this now for this entire process for going on probably 15 years. And I've tried to stay at the arm's length from it, even with David living as a neighbor down the road. The issue here, though, is one of improprieties alleged, improprieties proven, and the system itself. And after talking to David again today, I was on the talk show with Bob Bird, a very hostess here. And this is the second time. The first one was on the 16th of July when you released the press release. And we went line by line. And I gave my opinion on each one. We reiterated those lines today. And with pending this evening's meeting, after looking at this and very diligently looking at it, looking at other states in my old life, and I'm retired now, and this kind of feeble. But the issue here is I believe that there's a meeting, and I talked to David, and with his permission, I'll go down this route. This is as late as 10 hours ago, that there's a possibility with your projected concept of how it to work, and my understanding of how I would see the ideal world work, that maybe we can come to a meeting of minds and everybody can come out, not a winner or a loser, but with a system that works. And that's all I'm going to say. And that would consider, and I know you're going to go fall out of your chair, so brace yourself. And this would be through a consent decree. And if we have a consent decree where we are preceded by an MOU, MOA with the parties involved. So everybody understands what the goal is. And the consent decree then would allow for a finding of how the system can be improved, that is totally independent. And I go back to where it's been successful: Memphis, Tennessee, New Orleans, Louisiana, Minneapolis, St. Paul. I mean, I can go case by case by case and spend the next 6 hours in here and articulate it. But if you would consider that, I think I can really put a package together. And again, I bless this with David. David, you agree that
It's a potential solution.
and
Consent decree governed by the federal government.
for a time element specific to the agreement that the parties agreed are concerned. And it's made public. It isn't something that we're gonna hokey pokey around with this thing. There's a site, the site can be monitored, the site can be updated, and the progress made by that concept. And I've got a lot of other notes, but after David's excellent presentation here, I'm just gonna let it go. And unless there's questions, I'll return to my seat.
No, I really appreciate that. And I just want to comment just briefly on that. Yeah, if the federal government is, or federal prosecutors or US Attorney's Office, I think there's easier ways to solve this, and I think it's through our legislature. And I think, and I think there's, so I've gone around and around, like, do we impanel a commission to do this? Do we put like 5 people on a commission that look at these things? I'm just not, in the way the current rules are, it's almost an unworkable solution. One of the things that could happen is that report. So one of the reasons I wanted to make sure we published the process is because I want people to be able to challenge that process. Now, it's sort of a circular solution, right? How do you challenge that process? Well, you sue me in the courts, right? But the courts came up with the rules. But another solution is challenge me in an investigative grand jury on that process and have a report from an investigative grand jury. A grand jury investigated to look at the issues, what the Constitution requires, whether we're meeting the constitutional requirements of that, whether the court is meeting the constitutional requirements of that, and then they can push out a public report, right?
Yes, back with one follow-on question to your response there. The 3 elements that constitute a grand jury's necessity to meet don't meet those with, we're going to investigate that element of it. And again, I go back, to solve to resolve this, for everybody can believe in the process. And that's why I can talk to David for over 45 minutes today on it, Ken. And I think we really can do it.
Yeah,
And
and
again,
I think this is a starting place, right? This is a place that we can start.
At
We
least
can have
the
that
dialogue.
discussions.
At least the dialogue's there.
Yeah.
Thank you very much.
Thank you, Mr. Harpring. Your 3 minutes was perfect when you finished talking the first time. David, we'll get back to you when we get through all the speakers if we can. And I gotta say this, a legislator tried to challenge this in 2019. That was 6 years ago, and that was me. And it wasn't going anywhere. And you should read the record on Senate Bill 15, and you would be surprised at some of the comments from some of the legislators that now seem to be somewhat in favor of a solution, because they had fears about this process. And this is a different department of law. It may not be perfect, but at least he's here trying, when what shut it down last time was pretty obvious as well. So it's not always easy. This might be the opportunity, like Mr. Harpring said. Maybe this isn't the perfect process, but at least we're beginning with something and hopefully moving in the right direction. Next, Mr. Fritz.
Every submission on there will be reviewed by a grand jury. Is that how that is to be understood, or that it would be?
So it's the press breaking the rules. Thank you. We'll answer your question as we're answering the next one. Mr. Fritz.
I'm Donovan Fritz. I live out in Funny River. I'm a neighbor of Dave's. I've followed this case 10 years, maybe. He made a couple of statements about Dave presenting information to your office. I was a member of a board that Ann Helder, chairman, chair lady. The information that we provided was overwhelming that there is corruption in our judicial system. If the plan that you presented tonight is what you gleaned from the information that was presented at that meeting, you didn't read the information. So why should David Haig have to present it again? He has presented it numerous times.
And other people for him.
And that's all I need to say. Thank you.
So I'll answer the first gentleman's sort of question that he has. No, under the rules, not everything would go through, right? And that's one of the issues, right? And when I'm the gatekeeper, and so this gatekeeper is going to be like the blindfolded goalie, and a lot of things are going to get through because, first of all, public trust is at an all-time low, and we got to do something about that. So we're gonna let most things through, unless it's an obvious. When I say I'm still going to be a gatekeeper, yeah, probably. Like if it's a property dispute, like we talked about before, I'm going to say, kindly, this is not the forum to address a property dispute. Now, if it's a widespread property dispute with all the residents against a utility, well, there you go. That might be something that investigative grand jury can look through. But like I said, we've already had one come before us through the process, and we've pushed that out to an independent prosecutor. And I think there has to be a process, right? I think everybody deep down kind of understands that the process A is one controlled by a grand jury, not by individuals. And so even the stuff that David Haig mentioned, where the person, let me read it again. The power of grand juries is what's used in the Constitution, and then this is in the first handbook. So this is the very first Supreme Court came up with this. So they are part of that whole constitutional process. And in there they said, a citizen is at liberty to apply to the grand jury for permission to appear before it. Right? There's this process. What is that process? We've attempted to come up with a process that also complies with the court rules. Like I said, I'm not a fan of some of the portions of that court rules, and I can't do anything to change that other than to make a public comment, maybe put pressure on them to sort of change those rules. Because the last thing I want to be is this in this position. It's an unfunded mandate from the courts. We're taxed as a department already in trying to prosecute crime, try to deal with all the litigation issues you have against the federal government right now. So we're taxed already with our budgets. So the fact that now it's my budget going out to fund these, and it's an important process. It should be funded. The question is, where should that funding come from? And I didn't get any additional funding for this. So all of these outside contracts with attorneys that are fairly expensive, come at a cost to the budget. And I'm not complaining about that. I'm just going to further show the problems with the current process.
So if the website is in itself kind of a measure or a means by which to hone down and provide a quantitative methodology for the Department of Law to filter out maybe things that would be superfluous or unnecessary, things that would get dismissed. So it's like I said, a quantitative methodology for the Department of Law to get cases. Is on the other side of that, is there a quantitative methodology by which it can be objectively stated which cases would or would not go to a grand jury? Does that make sense? Like, rather than it being somewhat subjective still, even though there is kind of a process now in place, is there an objective way that can be?
Yeah.
People can have some assurance that, I guess, is where I'm going.
Yeah. Public welfare, public safety, pretty nebulous, right? And the courts put some guardrails on it, but again, people are going to rebuff against even guardrails, right? Because everybody's going to think, what is public welfare, what does public safety really mean in the terms of an investigative grand jury? And there's one of your problems right there. And so when the court put guardrails on it, rightly so, people were upset with those guardrails. When the court put sort of the process being, it goes to the Attorney General's office, people are upset with that process. But we're talking about it. That's the big step, is people are aware of it. And again, one of the reasons I was really adamant, trust me, I got pushback for creating a process for it. I got pushback a lot for wanting to put it out on the internet for everybody able to see. Because they had fears that the process would be abused and all this stuff. And I wanted it to be the most transparent process ever. Everybody knows exactly what needs to be done. And it's public whether or not it goes to an investigative grand jury. That's huge. Like if we outline an allegation against this department, it went to a grand jury and did not result in a public report. Well, that's more transparent than we've ever had in the state before. Sir, I don't control the rules of the court.
You can challenge them though.
Okay,
By-
next up, Mr. Southwell, please. It's your turn.
Not right, Treg, and you know it, and I gave you options.
get the troopers, go get that report, file against it. You could have done it in December. You held us off on our petition for how many months now? I am a petitioner. And you haven't even read my petition, I bet.
Mr. Southwell.
That gentleman and another lady in Anchorage. He knows it. And I just read you a letter today.
Sir, one of the things I swear to do
Walk outta here
is-
because you're politicizing this. You're not carrying out our constitutional protections under the Constitution. And you're a derelict of your duty.
Welcome to Soldotna, Mr. Taylor. Next up is Mr. Southwell. 3
I
minutes,
am
please.
Ray Southwell. I'm going to share with you my experience on the grand jury 7 years ago. But before I do that, I'd like to make a quote from Martin Luther King Jr. as he sat in jail in 1963. Injustice anywhere is a threat to justice everywhere. We are caught in an inescapable network of mutuality, tied by a garment of destiny. Whatever affects one directly affects all indirectly. In December 2017, I observed David Haig being tased in a courtroom while the judge stood on his lofty perch. The incident reminded me of King's comments about public safety and welfare. In January of 2018, I was a member of the grand jury. The local judge encouraged us to read the grand jury handbook, and I diligently studied it. By mid-February, it became evident that I had a lawful responsibility and right to share information with my fellow jurors regarding public safety and welfare. I developed a plan to accomplish this. On March 7th, 2018, I began discussing my plan with my fellow jurors. As I spoke, I noticed the deputy clerk turn off the recording device. Knowing the court rules, I instructed her to turn it back on. She eventually complied, and I continued sharing my thoughts. I intended to present evidence of the crimes to my fellow grand jurors on March 21st, 2018. I sent a memo to Judge Wells requesting assistance with this process, but she refused. On my next grand jury day, March 14th, 2018, I reiterated my plan. On both occasions, two different assistant district attorneys informed me that I could not bring such evidence. I was aware that they lacked the authority to prevent me from doing so. On March 21st, I was prepared with witnesses in the courthouse and had my written documentation. This time, the Kenai district attorney was present. He objected to my plan. I distributed a proposed report to my fellow jurors and went to retrieve my first witness. Upon returning with my first witness, I discovered the DA collecting the handouts and informing me that we needed to discuss my plan with Judge Wells. During the recorded hearing, I presented my thoughts to Judge Wells. On the phone, representing the state district attorneys, was John Skidmore, who was then the director of Alaska Department of Criminal Law. Judge Wells presented me with two options: dismissal from my grand jury or silence. I chose the latter. Grand jury understanding expanded over the following months and years. By 2022, 3 persistent individuals were compelling judges to permit such investigations. The court system sought guidance from its fixer, John Skidmore. Since our interaction, he has been promoted to Deputy Attorney General. Examining the available public documents and applying logical reasoning, it becomes evident that John Skidmore authored Supreme Court Order 1993. The Supreme Court was apprehensive about 3 persistent individuals advocating for grand jury investigations and hastily approved the change without thorough review. This order effectively halted the process of these three persistent individuals. I will conclude with this. My experience and my observations. When civil justice fails, street justice explodes, disrupting public safety and welfare, as Martin Luther King Jr. aptly understood. And I appreciate you listening. Good eye contact. Thank you.
Yeah, thank you for your comments, and it reminds me of one of the projects that you'll soon see also on the website, because what we have now addresses when you apply to a grand jury, right? For application. What we don't have that's public is the procedure to be followed when a grand juror themselves requests an investigation. And so that's my aim in the next couple of months, is to put that and make that public exactly. Because what we have is you have prosecutors, right? They're in a grand jury room. They're there to indict criminal cases. That's all they've ever done their entire career. In fact, they've indicted probably thousands of criminal cases. And when a grand juror raises their hand and says, I have an investigation that I'd like to conduct, their mouth sort of drop open and they go, I don't know how to do that. But we've provided some training, and now we're going to come and we're going to publish the procedures that those prosecutors will follow when when a grand juror on a criminal indictment says, I have an investigation, I'd like to proceed. We'll make that public. So what the process, and then all prosecutors will be held to that procedure. And I think that'll help. Again, my aim is to make this as transparent as possible under the current court rules that we're bound by.
Thank you. Ms. Reveal, please.
Thank you all for coming. I so appreciate you guys being here. I'll introduce myself really quickly here. My name's Gene Reveal. I'm a former law enforcement officer, investigator, and deputy coroner. I recently got an opportunity to watch the district attorney's office in action with a case that just concluded that is still waiting for sentencing, but the findings of guilt were there. A grand jury would be ideal to look into the enablers and the mandatory reporters that never filed a complaint with the school to have this man put in prison 5 years ago. And I think it needs to happen. I think the grand jury needs to see this. I'm happy that you have a process now and you will be receiving that from me. There was also an incident. There's incidents that happen off and on at the school. And one that happened recently was a group of students that claim that they saw a substitute teacher viewing pornography on a laptop during class. The principal at the kids' complaint, the principal immediately went and seized the laptops, identified which laptop was the laptop that was being used, and then declared, after the parents had taken their children to law enforcement and filed a complaint, the principal declared that there was nothing on the computer. That is a break in the chain of custody of evidence. And there is absolutely no excuse for that principal not sequestering those laptops and waiting for law enforcement to show up to take them into their possession and let their IT people look at that laptop. It's a tainted case. It's going to go nowhere, but you're going to be seeing it. I'll be sending that one in as well. Thank you very much.
Thank you, Jeannie. Mr. Garber.
Thank you, Peter Taylor and Miss Anna. My name is Thomas Garber. I'm a Micciche resident. Can you explain the process within the Department of Law? What process does the petition take to determine if a a special prosecutor is needed. I'm to understand by your website, if I read it correctly, that there's a 4-member committee within your department, 2 from civil and 2 from criminal, that will review the petition prior to making a determination if it's warranted to go to a grand jury. Is that, can you explain that process to me?
Yeah, the process is to see those threshold issues as described by the rule, by the court rules, to make sure that it is a matter of public welfare, public safety. The hope is that if it's not, we can put you to the right agency, we can put you to the right ombudsman, for example, or maybe this is an issue that can be appealed, but not everything is public safety and public welfare and corruption. And again, I've just mentioned that I intend to be I'm intending to let anything close go by, because I think right now we need to sort of reinstill public confidence in the process. And so, and again, I don't want to be the gatekeeper. So I'm going to take that as I can make those decisions and use my discretion to let more cases go through than probably actually meet what the court rules state. And so that's the process, and we're going to rotate. So it's not going to be the same individuals that consider these all the time. It's going to try to make this as transparent and non-conflictual process as possible. We're rotating attorneys out and in, and there'll be an odd number from the criminal and the civil, and then the next time there'll be more from the civil side and one from the criminal. So it's intended to be try to be fair. But again, when the complaint is about the Department of Law, that's going to go to independent counsel immediately, right? And then they are supposed to be working through those threshold issues. And then they are the ones that will impanel a grand jury, because we don't want to have any touches on that.
So you're saying there is actually another door that a petition has to go through, which is this committee. And now I understand you're saying you don't want to be the gatekeeper, so that's kind of creating another gatekeeper within the department.
Well, the idea was to take,
let me finish.
the idea was to take my footprint, my fingerprints off of it, right? Because the allegations are likely going to be against me or someone else. And again, in that case, it's going to go to an independent prosecutor to do that, to go through those court rules and then impanel a grand jury.
Yeah, I'm not attacking what you're saying. I'm just, one suggestion is that, I heard some people saying that, not enough evidence, or, they're just kind of vague about their petition. What about, somebody with special needs that can't articulate what their complaint is? But, it's great that you have these members within the Department of Law. Are they allowed to, inquire a little more, make sure this person isn't, special needs and can't articulate what they're saying? Or is there evidence out there that maybe this person can't get, but maybe whatever can help survive, maybe the ombudsman can be instructed to go get that evidence? And you understand what I'm saying? Maybe
Right.
that's my suggestion.
I think, no, I absolutely. And again,
I'm not saying that that door is not appropriate, especially where you're saying if it's automatic, if there's Department of Law people involved, that automatically goes to a special prosecutor.
Great suggestions.
That's great.
Yeah.
But, I'm just saying as a suggestion that maybe this committee could be a filter for, people that can't get their petition or accurate. Anyway, okay, so another question is, Supreme Court Order 1993 was issued December 1st, 2022, and you say it was unconstitutional. Why didn't your office appeal the constitutionality of 1993, and why did I have to? And why are you waiting for the results of that appeal? I gave oral argument July 1st last year. July 30th of last year, 1 year ago, and I'm still waiting for an opinion on that appeal. What happens when they come out with that opinion? How is it going to affect this new website?
I think that the most appropriate process will be through an investigative grand jury process for a number of reasons. One, I could sue the Supreme Court over their rule.
Why didn't you do it before you said you were in communication?
What's
You were in communication.
Let's walk through this. What's
Okay.
the result of me suing the Supreme Court over their rule? Is that going to instill public confidence in the system because they created the rule, right?
Yeah, but you were in communication
So that's
with them
why-
to create the.
So
You were in communication
that
with
is,
them.
that's my point. So the point is that this is best dealt with through an investigative grand jury process where it's independent of me, independent of the courts as much as possible.
I'm a little offended that I had to appeal the 1993 and your office did not, on my behalf or our behalf, appeal because you say it's unconstitutional. I told them too. I'm waiting for a decision. You probably could have got it faster than I could have. Anyway, my next question is, what is going to happen with the Supreme Court's issue of the anyway, I'm sorry. Susan Parks was, when I appealed or filed my appeal, I also I followed the instructions of 1993 and I submitted a letter to you to ask for a grand jury to investigate the relationship between the Department of Law and the Office of Children's Services. That request was made and your office appointed, or Special Prosecutor Susan Parks took that request, and I've had 2 meetings with her. And has done nothing since then, and she arbitrarily suspended that investigation or whatever. Nothing's happening, and she said until the opinion of the Supreme Court comes out. Why? You know, I don't, and Skidmore, in the contract, I had to go through a public records request to get her contract to verify that she was investigating what I asked to be investigated, not what she and Skidmore decided to investigate, and which is contrary. The contract is contrary to what I asked the department to investigate. So that's the problem with the petition on your website, is that you're going to give that to a special prosecutor, but is they going to have the arbitrarily going to be able to make it, shift it around? And am I going to be involved in that like I am with Susan? Am I going to be involved with this next petition that I did file online? And I received a notification from Ann that there is a special prosecutor being hired to investigate this 1993, everything you guys have done.
So
I have
would
2
you-
special
would
prosecutors
you rather a
now.
prosecutor from my office take that case on?
No,
given
no,
the
no,
inherent
no, no,
conflict?
I don't want to.
So when I appoint independent counsel, independent prosecutor, they're independent.
Right.
I could scream at them. I could
I
go
would
on
like them out of
television and
state.
say I don't like what they're doing.
Right.
The point is they're independent. As soon as I instruct them and they do what I say, the process is corrupt at that point, right? And I don't think anybody in here would want that to happen.
Right. The release of the report, Matthews could have an O'Leary hearing. If you read the O'Leary, that case had nothing to do but with how the process of going through the report to verify if nobody's names or, some allegations. An O'Leary hearing would be appropriate with that to release the grand jury. And I suggest your office, look into calling for an O'Leary hearing and ask for them to go through and see if there's anything that should be removed or redacted before it was released. It should be at least offered to be released. Even if it's redacted, then we can fight over it in court of what information that's been redacted can be unredacted. My last question is,
Mr. Garber, you're,
okay.
you're on
One
your,
more?
you're on your third 3-minute.
Can the
I've been
ombudsman
pretty generous.
submit a petition?
Sorry, before we move on, I just want to check when our flight is. I don't want to cut this. I want to go as long as we possibly can, but we're going to look at the time of the flight just to make you aware.
And I'm trying to get through everyone, so I don't mean to rush
I know,
anyone.
I
but
know. I
we still-
appreciate your
Yeah.
and I'd like to have another opportunity. Thank you.
Okay, Patty Wright. Bob, you didn't even sign up. I'll add you to the list. Ms. Wright? Pardon? Okay, that brings us to, and I'll leave her name on the list in case she's in the restroom or something. Wynette Coleman. What time you gotta go?
Flight's at 8:20.
Thank you again for coming. My name is Wynette Coleman, and I've lived here on the Kenai Peninsula for about 31 years now. And didn't get much involved with a lot of politics until probably 2016. Got exciting. I have a question. Why don't you, Mr. Taylor, why don't you lodge a complaint to, in your own process or what have you, to a grand jury to look at Judge Matthews? You had kind of mentioned that earlier, to see why he will not release it. And then I don't understand the O'Leary yet, but I'll learn about it.
Can I interrupt just for 1 second? 820, what airline? Okay, let me just make a couple texts while you're doing that and just see if they're gonna, if it's 820, you should think about it pretty soon, but let me see if I can get a response that they're gonna hold up. If not, I can keep taking public testimony so we have it recorded. And then you will be able to review.
I'll
it.
rely on you. You know the airport and Grand Aviation, so it wouldn't be the worst thing to be stranded down here.
So I don't know if that was exactly a question, but yes, can you and your department?
That is a really interesting concept and one that I hadn't ever contemplated before, actually. So I really appreciate that. That is something that we'll actually look at and see. Now, on that specific, I'm thinking of other issues. On that specific case, I mean, the court record's there. I think it's public exactly why he rejected that report. It would be interesting. I think the idea is I think probably the best result would be to have an investigative grand jury look at what occurred in the first grand jury. I think that investigative grand jury could get that unredacted report, and then they can decide what they want to do with that report. And I think that is probably the best way forward to move forward on trying to get that report public.
That would be great. Also, I have a question, when we were earnestly and diligently, consistently, persistently coming before the Kenai court, standing out front in whatever weather, inclement or great weather, what have you, for a very long time. It was interesting that the court came up with a bulletin. Are you in charge of those bulletins, or is it just the courts? They have bulletins
I
that
have
feed out
I have zero
information.
authority over the court, so that
Okay.
if it was a court bulletin, then I had nothing to do with it.
Okay,
No.
so my rights as a citizen, as a public citizen, be able to walk on the sidewalk, that was the only part I was allowed to do. They put out a bulletin that said, you may not come onto the grounds of the court. Now, this is the very place we go to sit with our peers and to make judgments and calls and listen to information and witnesses and so forth. And yet we were told we could not hold papers, hold signs, hold flags even. It got very picky. They went extremely extreme on that. I find that interesting. And it was submitted to all of Alaska, all the courts. And investigating that part of it, apparently, they're not exactly a public entity, but we're brought before them. That's where we go, is to the courthouse, but they're not actually a public entity because it's owned by Department of, what was it, guys? I don't want to say Interior, but it's another commissioner department of the state. The state owns it, but yet I do believe that we, as the citizens, have more say-so than the court judges. They were to be the least, Mr. Treg, in making, excuse me, Mr. Taylor, in making laws. It was the least of them to do that, and yet they present all kinds of laws that are truly unconstitutional, and they should be accounted for. And this is the way to do it, and we want to do it the right way as a citizen, to be able to go before them and say, you cannot do this. And yet they put us, that bar that you stated earlier, they put that, and we can't get across it. That's wrong. It's completely wrong. It is not part of the Constitution. It's not part of the United States of America. I know that's a big preaching thingy, but that's the way I feel. Thank you so much.
Thank you, Wynette. Barbara Seward, please. My staff is checking with the airline, and you either have to go really fast or we have another option, so. Okay, Barbara?
Hello, I'm Barbara Seward. Thank you for coming. I'm from Funny River. I just was wondering about when Dave Haig went in June at there was a Synergy Symposium and we were rallying out there. And I was wondering, number one, why the governor did not. He went out the back door and we're right next to the office. And appreciate you coming out and speaking with us. But I was a little disappointed to hear when David Haig, I mean, I have it on video, 1 minute and 45 seconds, how he was telling you about the corruption and you said you have not seen the report and this and that you have to agree to disagree with Dave that there's any corruption. Now, how can you even disagree on something if you haven't seen it? And you didn't sound very willing to, just stop and listen and say, I will check into that. I mean, you can't agree to disagree with something. So in other words, you didn't at the time see that there's any corruption in the judicial system there. And what changed your mind? And also that was from June till now. And also, I was wondering, they're supposed to impanel 18 jurors for the grand jury? Right?
Yeah, they can impanel up to 18.
18
The
and
minimum is 12.
And they can be up to 24 for, they're supposed to have alternates. So why was there only 12? And then that juror goes missing and nobody seems to be interested in what happened. If I didn't show up for my jury duty or whatever it was, they'd be knocking at my door. Also, if we can't seem to get this solved, if we don't have public trust to even figure out what quote independent is, I mean, if there is corruption there to be seen and they're gonna in-panel a commission, maybe we need to really go outside and do federal and get maybe Pam Bondi and her team to come in and look at it. That's all I have to say. Thank you. But I do want to know what changed your mind.
So not a change of mind. The question that I was asked when I came out of the conference and spoke with all of you there was whether or not I thought there was corruption within the Department of Law. And at that time I said, no, I don't believe there is corruption in the Department of Law. First of all, if I thought that, you would see action taken on my behalf and we would do something about that corruption, right? So that was the question asked. And then
what do you think now? Now that you've heard these testimonies and Dave Haig showed you some.
I think we have a need for a procedure that is public, that prosecutors will be required to follow in the event that invests in a grand jury situation. A grand juror says, I have an issue I think we should investigate. And if that policy is public and readily available and a prosecutor does not follow that policy, then they'll be subject to disciplinary action. That's what I think about that. And then you mentioned that I want to answer your missing grand jury question. It's not a mystery. The court case that was public, and this is the only reason why I can talk about this, is because of that court case. He elected not to come. He thought it was a waste of his time, and that's what the record reflects. He thought it was a waste of his time. I think this thing had gone months, and he just had enough, and he decided he was not gonna participate anymore.
But I've been on juries before, and you have alternates. If the Department of Law was doing their job, they would make sure that they would have alternates there.
I think I've addressed that issue already tonight, but I'll go through it again just a little bit so you understand. When I appoint an independent prosecutor, I don't get to question his decisions or her decisions, right? If it was a prosecutor that we put, right, but we couldn't do that because there was allegations of corruption against the Department of Law.
But
right?
there's laws they have to follow, and
Right, and the law is that
that
there's a minimum of 12 on a grand jury. And so for whatever reason, for again, he's an independent prosecutor. I don't get to tell him what to do. Otherwise the process would be corrupt, right? It's not independent if I can say, do this, and do that. I don't get to make those calls.
Well,
For whatever reason he impaneled a jury with 12 jurors. That is not something that I can
that
control.
sounds corrupt right there. I would look into that. Thank you.
There is guidelines, and the minimum is you're required to have at least 12 grand jurors. Those are the guidelines.
Okay. Mr. Carpenter, please. David, if there's time at the end, you'll have a chance to come back. Are you
Thanks.
just hot? Just warm?
In the interest of time, I'll keep it quick. Ben Carpenter from Micciche. Technical question. Who is the person who receives the submissions from the website? And who makes the decision for it going forward? That's the technical question.
The person that receives it is probably going to change from time to time as personnel change positions. But when they come in and the submission comes in, then it goes, if it doesn't have any allegations or it doesn't touch the Department of Law, then it's going to go to that panel of attorneys that review it for the threshold issues. And assuming it meets those threshold issues, which again, my policy is that we're going to let most things through, then it'll be referred out to an investigative grand jury.
So I would assume, as a follow-up to that, I would assume that that panel is going to be less than 12 to 18 members of the Department of Law reviewing.
So that panel is currently 3, and correct me if I'm wrong, and it's going to rotate between 2 on the criminal side and 1 on the civil, and then 2 on the civil and 1 on the criminal, and it's not going to stay with the same group. Because what we don't want to have is an allegation that the panel itself is corrupt, right? We want to rotate it through the department to again try to be as transparent and fair in this process. And
my final question, and then I'll go sit down, revolves around the court's decision to point to the Attorney General as the gatekeeper.
Yeah.
And we've heard multiple times that you are in opposition to that decision of their prerogative. The Attorney General and the Governor also have a prerogative. What would be the fallout or the consequence of the Attorney General and the Governor just not following what the court thinks the process needs to be? Because it's not spelled out in law and it's not spelled out in the Constitution. Then you can have your own process. So you've already said that, hey, I'm going to take a liberal approach to this process that I've created. In my mind, 12 to 18 members can decide whether they want to investigate something just like they used to do previously. And that's the direction that returns trust to the system. So all you would have to do is say, here, we're collecting this information. We'll pass it on to the grand jury. Those 12 to 18 members can very quickly decide that they will or will not investigate. I mean, we can trust them to make that simple decision because we can trust them to make a decision as to whether they're going to indict somebody. And then the whole process, this whole issue goes away because it's the grand jury saying, yes, I investigate, or no, I don't investigate. And then the prosecutor can be on the other side, your 3, right? They can be saying, oh, wait, they didn't want to investigate. Well, here, you can take this issue to the ombudsman. You can take it to this other direction to resolve your issue, but the grand jury has made a decision that they're not going to. So it seems like all it would take would be a decision on your part to say, well, we're not going to follow the court and we'll institute our own process, and it's more constitutional than yours. So
you heard me describe what I view my role as the blindfolded goalkeeper, right? Because I intend to put these things through to a grand jury. Because you're right, we're at a state where public confidence is low in the system. And so we want to try to correct that as the best as we're able to do. Now, are we going to satisfy everybody in that process? No. But we're going to try to be as fair as we can under the current system that we have.
For the record, I attempted to try to get you to not be the gatekeeper.
Thank you.
And your deputies resisted my attempts while I was in the legislature.
Thank you, Ben. You have now 20 minutes before you have to leave because your flight will be at 8:55. So we got you got you a little bit more time and you can all fit on that one. The Attorney General was not listed on this flight anyway, so we got that straightened out too, apparently. So you weren't going anywhere.
Yeah.
Anyway.
Thank you for getting me on that flight. 'cause
Everyone
I
else
have
was.
Mietings in Anchorage in the
Might
morning.
talk to your staff
Yeah.
about that.
Yeah.
They might have meant to leave you overnight, but
Thank you.
Mr. Byrd, where are you? Bob? Okay, we're gonna go online. We have 5 people, 5 hands up online. If you can tell us their name, I'll ask them to use their 3 minutes wisely.
Tyler Bose.
Say that again.
Tyler Bose.
Tyler Bodes, you have 3 minutes, please. Thank you.
Hello. Hey, first of all, thank you, Mayor Micciche and Attorney General Treg Taylor for doing this. I know you didn't have to come down and hear this, but I appreciate your time. I live in Wasilla. I signed in because I have a unique perspective on some of the problems in Alaska. I was an FBI agent for 12 years, worked public corruption violations in Detroit, Puerto Rico, and 6 years here in Alaska. And I must say, Detroit and Puerto Rico are pretty corrupt. I've never seen any place like Alaska. Every time I worked a federal public corruption investigation, it was corrupted by either federal or state officials. For example, without getting into too many details, one of the things that has happened recently is since I kind of went public about 8 or 9 months ago with some of the issues with FBI Anchorage, I have gotten a ton of phone calls requesting help. So when Attorney General Taylor, you say you don't think your department is corrupt. I mean, I get it, but I've had so many complaints and there's so much smoke within the Department of Law, the Department of Public Safety, and Office of Children's Services that I don't know what else to conclude than other than it is corrupt. Like, for example, how would you handle a prosecutor of yours going to a minor child against their parents' explicit denials, interviewing them before grand jury, and then telling that minor to shut up about it and not tell anybody about it? That happened. I have evidence of that. How would you react if the state, I know it's not your department, but the Department of Public Safety, multiple officers, troopers in different cases, overtly lying in affidavits and in grand jury, and the Department of Law just picking it up and running with it as if it's fact? That again, I have proof of in multiple situations. It's just over and over again in this state. And one of the things that you keep bringing up is this independent prosecutor. Again, like, one of the things that I've seen in this state is that all the attorneys in the state, whether you're on the defense, the prosecution, or other, they all want to be friends after work. It's just so, in my view, incestuous that the only real way that you're going to be able to have a good independent prosecutor is if you go out of state. I've attempted to do that, to bring in attorneys from Michigan, where I used to work. They're very much interested in some of the stuff that's going on in Alaska, as is, honestly, the Civil Rights Unit at Department of Justice. I've had pretty good conversations with them about what's going on. One of the other things that I have kind of bounced around, in fact, I got this idea from a current legislator, was introducing an Office of the Inspector General for the state of Alaska, an independent elected Office of the Inspector General to specifically address some of the negligence or misconduct that goes on specifically in the Department of Public Safety and Office of Children's Services. More to follow. I just wanted to thank you for taking my comments, and thank you for your time. Thank you, Mr.
Bodes. Treg, do you want to comment?
Yeah, absolutely. I mean, you pointed out a couple things there. One, it is difficult to get an independent prosecutor, and we have considered going out of state, and we'll probably likely have to do so for many of the cases that we've we're on notice that many people are going to be filing cases, so we're going to be busy for a little while. And we're going to have to find independent prosecutors to take those on. So that may very well be an out-of-state prosecutor or somebody out of state that doesn't have any ties to Alaska. And what some of the other things you described, if you've got evidence of these things, please submit them through the process. Like I said, I'm pushing them through to investigative grand juries. And that's the process that we have. And you know what the process is. You go through the process and it fits it, and it's a matter of public safety and public welfare. It's going to go to investigative grand jury.
Thank you, Trey.
Because I'm as concerned with you about the state of public trust right now in the justice system. As the lead prosecutor for the state, that's really concerning. We want people to have confidence in the system. We want people to report crimes and have confidence that those crimes are going to be investigated appropriately and referred to the Department of Law for prosecution appropriately and courts deal with them appropriately. And if people lose that confidence, you're right. I mean, what are they left with? And we don't want to see people taking matters into their own hands when we're supposed to have a process that serves the people. And I'm confident that 99.9% of the time we get it right. But I'm also cognizant that there's 1% of that we probably don't get right. And so, the reason I'm down here is I want to be a part of the solution. I want you to understand what our thoughts are, what our thinking is on the process, and just make you aware of where I'm at with the process and possible solutions for that process. So that's why I'm here.
Thank you, Trey. Next online is
Sharon Walls.
Sharon Walls, please. You have 3 minutes. We're going to try to get through the remaining. You have 3 after that online, and then Mr. Bird. Is that correct? Yes,
Hi,
okay.
thank
Sharon
you.
Walls, you have 3 minutes. Please proceed.
Hi, Mr. Taylor. I am Sharon Walls. I am the wife of the police chief, former police chief of Ketchikan. I just want to address your article today. I'm happy that you actually had the gall to and guts. I appreciate that and I respect that, to step out and say something. Without having somebody else like John Skidmore do it for you, which is what has traditionally been done. But what I'm concerned about is that you state in your article, here's what really happened. And this case was never adjudicated. This case never went to a jury. And what you say really happened, I have the recordings from that evening. I don't know if you know this, but our attorney told your prosecutors that they chose not to take them or listen to them. And so what you said in your article today, I have the recordings that dispute that. I would love to play them for you if you haven't heard them, but you are in possession of them. Well, not mine, but you're in possession of the troopers, and it completely disputes what you said. Not to mention that what you put in there was pretty much a cut and paste, but you left out a few different things. You put in a couple statements that suited your needs, but you left out the 5 other witnesses that said something completely different. I am not feeling as gracious as Mr. Haig when he says that that he's going to give you the benefit of the doubt, because you didn't have to publish that article today without really looking into what happened. Because if you would have listened to the recordings and you would have listened to me telling one of your prosecutors, have you listened to the recordings? Because they're completely different than the affidavit. And then you could listen to one of your prosecutors threatening to charge me with some crime if I testified in front of the grand jury. I asked repeatedly, what are you going to charge me with? I'm the victim here. This man attacked me. I did nothing. I did nothing. And my husband, his actions were moderate in consideration of what happened. And I was there. So please don't call me a liar as well. You've already done that once before. I think it's insulting that you wrote that article because there hasn't been any complaint lodged to your wall of silence. This new website that you want us to put a complaint to. There were others, and I also would like to point out that your allegations against the trooper that you say was paid for, I think you're combining this with another law enforcement officer who wasn't paid for, who wasn't a witness, that stated his claim of what your office and what the trooper said was a lie. I think that if you really want to get this right, I think it would be beneficial if you listen to all the audio. We could do it together. I'm open to that. And I pray for you. That's all.
A chokehold on him, and it requires 2 employees to pull off. So when law enforcement investigated that, I don't have investigative authority. I can't investigate those crimes on mine. It takes law enforcement. And if law enforcement doesn't refer those to me for criminal prosecution, those criminal prosecutions don't occur. I need law enforcement to find that they think that there's something wrong and that something happened that violated the law. In this case, law enforcement thought the law was violated, and they referred it to prosecution. And I do what I do when law enforcement refers things for prosecution. I prosecuted the case. All of that evidence that you have, it could have come out in trial. That is perfectly acceptable to prove the innocence. Is all of that evidence. We looked at the evidence, and we and the troopers looked at the evidence, and everybody that looked at the evidence thought that an assault had occurred. And so I stand by that article.
Thank you. Next online is next online is,
Candy with the Liberty Cap Gazette.
what's the first name?
Candy.
Candy, can you please give your last name, and you have 3
Yes.
minutes?
Andy Hay. I'm in Anchorage. I have been,
I'm Liberty.
I
Well,
beg
he responded, and which I think he lied.
Can you please mute the others? There's someone speaking online that is unmuted. Okay, you're muted now. Candy, go ahead, please, and speak up.
basically what I've been following this for quite some time. I've been very interested. Attorney General Treg, Taylor, you repeatedly said that you don't have, there's no procedure. If I might make a suggestion, there is actually a rather small book that is easily available. I cannot say, I'm on a fixed income, so I really don't have the funds to send you a copy. But the name of the book is The People's Panel. It's the grand jury in the United States from 1634 to 1941. And it was written by Richard D. Younger, Younger. I would strongly recommend this book. It is very simple. It explains not only the history of the grand jury, which goes back to, I believe, somewhere around the medieval period of in England, Europe, and forward. So this is what the founders of the United States knew when they wrote the Constitution of the United States, which set forth the original grand jury stipulations. So I would strongly recommend that you read it. It's not that terribly long. And I think you might gain some enlightenment and some ideas about how the real purpose of the grand jury, which according to our founders was specifically, and their ancestors back several hundred years, was the purpose of the grand jury is to stand between the individual and the state.
Thank you, Candy. We're trying to get two more testifiers in here. Mr. Taylor, do you have anything for Candy?
Just thank you for that recommendation. Thank you.
And the Attorney General is a public employee, so if I need to buy him the book, I'd be happy to do so. Okay, next is Dave Maxwell, please. We're going to try to get two more in before they have to leave in about 6 minutes. So go ahead, Dave. Mr. Maxwell, you may be on mute. Gone? Okay. All right. We're gonna go to Paul Nelson online, please. You have 3 minutes, Mr. Nelson.
Thank you. My name is Paul Nelson. I'm calling from Haines. And my internet connection is very poor. If you lose me, I will get right back on. The Attorney General states that the grand jury and their proceedings are confidential. Yet the Attorney General requires a form that requires the people to state the reason they need to approach the grand jury. There is no confidentiality in this procedure. I suggest that a person be allowed to approach the grand jury with an issue and let the grand jury decide if they will hear this issue. Without to approach the grand jury, people need open access to the grand jury. And my connection just dropped out.
We got you back,
Okay, thank
Mr.
you.
Nelson.
I have stood before a grand jury and been ordered out of the room by the district attorney. When I asked the foreperson of the grand jury to order the district attorney out, the foreperson ordered the district attorney out. I then asked the grand jury if they had seen the grand juror's handbook. They said no, they had no idea what the handbook was. So I have personally seen cases where the grand jury has not even been informed of their rights and duties. Thank you for your time.
Thank you, Mr. Nelson. Mr. Taylor?
Yeah, I'm happy to respond. Thank you for your comments. You know, all the power again lies with the grand jury. It as it's spelled out in that original handbook, the grand jury has the power to hear complaints, and people have a right to apply for the grand jury, according to that old handbook that was done by the first Supreme Court that we had in the state of Alaska. There was an application, and the Constitution talks about a grand jury's authority to hear these complaints, and they control it. It's not you and I, the individual, who control that process. I think we all understand that there has to be some type of process, right? We can't just simply anybody that wants to at any time demand a grand jury's time and walk into a courthouse unannounced. I think everybody sort of understands at a low level that there has to be some type of process. And to the point about the application process through the Department of Law, again, the beauty of that process is that it's public, right? And because right now, if for example, David Haig takes all his complaints, right, to a grand jury, and he's able to speak directly to a grand jury, and they investigate, and they decide not to issue a report, no one would know that grand jury occurred except for David Haig or anybody of the other witnesses, right? And so there's the shadow of what occurred, why didn't it, what happened, is it evidence of further corruption? And so one of the things when you apply outside the grand jury process through the process that we've described is that it's public what the complaint was. It's public whether that went to an investigative grand jury, right? And then it's public once a report's issued. And again, I don't agree with the courts on their reading that they have a right to prevent a report from becoming public. That's one of the areas I do disagree with the courts on.
Does that mean that searchable by the public and we'll be able to see everything that's been filed and what status?
To a certain extent. So we went back and forth within the department, and maybe we didn't strike the right balance. Interested in some of your thoughts on this. We're not going to disclose the name of the person who filed the complaint, right? Because we don't want them to fear retribution from the system. And so the overview of the complaint is just going to be that, an overview of what the complaint was, and that'll be public. Because we do understand that there is sort of a fear that there might be retribution in the system. And then the next thing you're going to see on that page is when it went to an investigative grand jury, and whether it went to an independent prosecutor or not. And then finally, any report that resulted from that. And again, that's a lot more transparency than we've ever had on that aspect, right? Again, because it occurs in the course of a grand jury.
Okay, last one, Mr. Maxwell. And that way we'll have a couple seconds for some closing comments. Mr. Maxwell, as briefly as possible. I'm sorry to do that to you, but I've already canceled one flight, so go ahead.
All right, can you hear me?
Yes.
Good, glad to hear it. Please don't cut me off. Hey, I am a whistleblower. Treg Taylor knows about it because I had a private meeting with him and Governor Dunleavy. I was retaliated against for whistleblowing. I got fired. I showed them evidence. Their excuse to me, as I'm the one that brought the lawsuit against the state, because no attorneys I found would actually step up to the plate because they don't want to get involved in something that detours them and their possibilities of becoming an attorney general. I've found that out on the inside, but I also found out that I could do a lawsuit on my own. I did. I brought it to Treg Taylor. He gave it. Unfortunately, it really shows kind of a low class individual when you do this, because I'm talking to him and the governor, and he gives it to Andy Miller. And Andy Miller sends it back to me and says, well, sorry, statute of limitations. Here's the problem with your statute of limitations, and I would like an answer from Treg Taylor himself. When the government is the one that is in the mode of stonewalling, I want to know, do you even look at that or consider it, or do you just recognize that the government's got all the power, and so you just declare statute of limitations, citizen, tough luck? That's the end of it. Thank you. Please give me an answer.
Yeah. No, that I don't draw the statute of limitations line. That's not something I get to decide. That is a decision for the legislature to decide, right? The people you elect there. And in order to pursue that that line, unfortunately for you, that the statute of limitations had already expired. It didn't stop us from investigating and looking into your allegations. And so there is, on most crimes, there's very few allegations that don't have some sort of statute of limitations, and there's good reasons behind that. There's some policy reasons. You can disagree where sort of the legislature's put that line, but some of the reasons that you have statute of limitations is because memories fade, witnesses die, information gets destroyed. And so one of the hallmarks of our system is that people are able to put up an adequate defense, right? They can face their accuser in court and put up a defense, and they can use all the information that they have to support their defense. And that's through a passage of time, 5-10 years on some crimes, that just is no longer available to that information, that person. Those documents have long since been destroyed according to the document destruction policies that every corporation has under the law. And so I'm not saying that I agree with all the lines of the statute of limitations. I'm not expecting you to agree with where they have that line, but that's just a reality of our justice system, and there's reason for it.
Mr. Taylor, you want to give some closing comments? I'll close it out, and then you are going to have to leave.
Yeah. Thank you. I really do appreciate, I know we've received a lot. We knew we were going to get really hard questions here, and some people that really are passionate about the issues. And my thanks to you is really sincere, right? I think you are bringing up some issues that need to be addressed. And, but I hope you also understand that this process, although not perfect, is a good avenue for addressing these concerns. And I want to be as transparent as I can under those rules to make it sure that the public's aware of what's going on. And my ultimate goal is the same as yours, is have confidence in our system, where you have a breakdown. And if you don't have confidence in your election system, you don't have a democracy very long. If you don't have a confidence in your judicial system, you don't have a society for very long. And so my attempts, although imperfect in this procedure, are to be as transparent as I can, to be as helpful as I can in this process, and to assure that people have access to an investigative grand jury for those things that an investigative grand jury should have access to.
Thank you, Mr. Taylor. I appreciate that very much. I want to thank you for being here. I know you have to go. I have a couple of comments of my own. Thank you for Ms. Hulser for being here as well, and your staff. This is pretty unprecedented, and I'm very appreciative. When I ran Senate Bill 15, I had a department that was unwilling to help guarantee your rights under Article 1, Section 8 for grand juries. So this may not be a perfect system, but I do applaud you for trying. And sounds like you're open to suggestions as we work through this. It may not be perfect, but I do invite you all to read the record on Senate Bill 15 back in 2019. It was we were shut down. David was there. David testified. You'd be surprised what some of the conservative legislators had to say at the time. There's been resistance, and I really appreciate you being here. I think we may get there. It may not be perfect at first. I appreciate all of you being here tonight very much, as well as the 43 people online and those that were willing to testify. And I'll always be willing to host further discussions here, try to move this issue forward. So to all of you, thank you so much for being here, and have a great night.